Is NDAA 1021 imprisonment constitutional? For an explanation of NDAA Section 1021 imprisonment, let's listen to Ron Paul.
Thank you, Mr. Speaker. Mr. Speaker, I rise today to introduce a very simple piece of legislation to repeal the infamous Section 1021 of the National Defense Authorization Act, quietly signed into law by the President on New Year's Day. What a way to usher in the new year. Section 1021 essentially codifies into law the very dubious claim of presidential authority under 2001 authorization for the use of military force to indefinitely detain American citizens without access to legal representation or due process of law. Section 1021 provides for the possibility of the U.S. military acting as a kind of police force on U.S. soil, apprehending terror suspects, including Americans, and whisking them off to an undisclosed location indefinitely. No right to attorney, no right to trial, no day in court. This is precisely the kind of egregious distortion of justice that Americans have always ridiculed in so many dictatorships overseas.
According to the United States Constitution, the privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion the public safety may require it. According to Black's Law Dictionary, 1st edition, 1891, the word rebellion refers to deliberate, organized resistance, by force and arms, to the laws or operations of the government, committed by a subject. It's impossible to say for sure what definition the Founding Fathers of the United States of America had in mind for the word rebellion when they wrote about it in the Constitution. Even if they discussed the meaning of the word publicly or explained it in writings, there would be no way for people to confirm such things with complete certainty today. Is NDAA 1021 imprisonment constitutional? I propose that the answer rests with the definition of the word rebellion that was intended by the framers of the Constitution of the United States of America. Constitutionality does not necessarily mean something is morally right.
The Senator from Arizona.
I listened to the discussion by Senator Rand Paul and understand his theory. Facts are stubborn things. 27% of those who have been released have been back in the fight. That's fact. That's fact. And some of them have assumed leadership positions of al-Qaeda. That's fact. And if the Senator from Kentucky wants to have a situation prevail where people are released and go back in the fight and kill Americans, he's right. He's entitled to that opinion. But facts are stubborn things. The facts are 27% detainees who were released went back into the fight to try to kill Americans. Mr. President, I suggest the absence of quorum.
In that clip, John McCain claimed that indefinite imprisonment is necessary in order to protect the military. Once again, the Constitution says, the privilege of the writ of habeas corpus shall not be suspended, unless when in cases of rebellion or invasion, the public safety may require it. Let us remember that refusal of due process by the United States government is not new.
I want to take a moment to explain Korematsu and the case. Now, some of you may be too young to remember Mr. Korematsu and his fight against Japanese internment during World War II, but I am not. One of the singular experiences of my lifetime was when my father took me as a small child to the Tanforan racetrack. That racetrack was a few miles south of San Francisco. And during World War II, it was taken out of action as a race track and turned into an internment camp. It was fenced with barbed wire. Small buildings line the center portion of the track. This is a better, you can see, here's the racetrack, and here are the buildings. And this is where Japanese Americans were essentially incarcerated for the remainder of World War II. One young Californian, and let me show you, this is, while we have it, this is the order which essentially from the Western Command and 4th Army Wartime Civil Control Administration, instructions to all persons of Japanese ancestry living in the following area, and that's the area, the city and county of San Francisco, lying generally west of the north-south line, and it describes that. All Japanese persons, both alien and non-alien, will be evacuated from the designated area by 12 o'clock on Tuesday, April 7, 1942. No Japanese person will be permitted to enter or leave the above described area after 8 a.m. Thursday, April 7th. That's over half of the city of San Francisco, without obtaining special permission from the provost marshal at the civil control system. And then they are told where they are to report to the civil control station to receive further instructions. This must be done between 8 a.m. and 5 p.m. Thursday, April 2nd, or between 8 a.m. and 5 p.m. Friday, April 3rd. That's their notice, and they turn up, they get in a bus, and this is where they go and where they remain till the end of the war. One young Californian, Fred Korematsu, challenged the internment. He took his case all the way to the United States Supreme Court, and he argued that the United States Constitution did not permit loyal American citizens to be forced into these camps solely because of their Japanese American heritage, which was the case here. The Supreme Court heard his case, but he lost in a decision that is considered by many to be a black stain on the jurisprudence of our Supreme Court. Decades later, in 1983, Korematsu challenged his conviction again. This time, he was represented by a team of volunteer lawyers, including Edward Chen. This team put forward newly discovered evidence that demonstrated that prosecutors in Korematsu's original case had withheld evidence. Specifically, they had withheld United States government intelligence at the time that indicated that the internment was neither necessary or justified. That was the intelligence at the time. This time, they won. So 41 years after the original internment order, Fred Korematsu's conviction was overturned by the district court. And 4 years later, in 1987, President Ronald Reagan signed into law the Civil Liberties Act, which issued a formal national apology for the Japanese internment. Well, at the time, Chen was speaking to a group, at the time of the case, to a group of students. I beg your pardon, let me begin again. Chen was speaking to a group of students and reflecting on the funeral of Korematsu. And he said that at times he had experienced, and I quote, feelings of ambivalence and cynicism when confronted by appeals to patriotism. Now, he was referring to the internment of Japanese Americans, citizens, for no cause other than they happened to be of Japanese heritage. I would think you could get a bit cynical about that. And people that didn't see this don't really believe it ever happened. But it did happen, and it happened here. And this was the condition in which people were kept. And it's just not right. Well, the feelings of ambivalence and cynicism when confronted by appeals to patriotism was the line that some have picked out and tries to use to paint Chen as unpatriotic. But they didn't know the context. Sometimes, things that have monumental importance at the time, like the internment of Japanese American citizens without due process, fade too quickly from our historical memory. And so I thought I would bring it back so that this body could understand the total context. This was a very big deal. It was not a proud moment for our country. And this Congress and President Reagan rightfully issued a formal apology for the injustice that was done years later. To take a quote from a speech after Fred Korematsu's funeral and use it to try to imply that Edward Chen does not love his country, it's shameful. It's also flatly inconsistent with the rest of the speech. Chen went on to say that when the congregation sang America the Beautiful at Korematsu's funeral, he was moved to tears, quote, because the song described the America that Fred envisioned, the America whose promised beauty he sought to fulfill, an America true to its founding principles, end quote. Well, Fred Korematsu is no longer with us, but his daughter Karen sent me a letter about Edward Chen, and here are some of her words. My father's belief in our Constitution was unwavering, even when he was treated unfairly. Like my father, Judge Chen is adamant about upholding the Constitution without bias or prejudice. So in my view, Edward Chen is a judicial nominee who has been treated extraordinarily unfairly, but he remains steadfast in his commitment to serving our country as a federal judge. And he has a 10-year unblemished judicial track record to show that he will serve us exceedingly well. So I urge my colleagues to vote yes on the nomination of Judge Edward Chen to be a district judge for the Northern District of California. Thank you, Madam Chairman. I yield the floor. I note the absence of a quorum.
Clerk will call the roll. Mr. Akaka.